Welcome to Academyhub. In this series titled To the Point, we will be uncovering several minute legal intricacies with regard to some sensational issues that we often come across. And in this first episode of the series, in the light of the remarks made by the Allahabad High Court with regard to imposition of preventive law, what we call National Security Act, we will be trying to figure out the meaning and extent of the act. But before we begin, let's break the ice with the help of this.
As per an investigation of police and court records conducted by the Indian Express in the state of Uttar Pradesh during the time period of January 2018 and December 2020, 120 habeas corpus petitions were filed challenging the imposition of National Security Act by the state government. Out of 120 cases, 94 detentions were quashed by the Allahabad High Court with several critical remarks, and the detainees were set free. Out of these 120 cases, 41 were in regard to cow slaughter, and 30 of these 41 were quashed, and 10 of the remaining 11 were provided bail. In 11 of these detentions, the court noted that there exists non-application of mind by the authorities while invoking the law. While in 13 detentions, the court noted that the detainees were denied the opportunity to represent themselves effectively while challenging the National Security Act. Moreover, in 7 of these detentions, the court said that the cases were of law and order and does not come under the ambit of public order. Furthermore, the court also remarked that the substantial information in the FIR are cut and pasted in multiple cases and the authorities have used the law in arbitrary fashion. To note, National Security Act is preventive law which came into existence in 1980 substituting MISA. Accordingly, an individual can be detained pre-commission of offence on the ground of reasonable suspicion that he or she is likely to commit an offence which can disturb the public order or peace and tranquility of the region.
Now, if you look at the grounds on which this preventive detention has been made, then the data says out of 120 cases that reached Allahabad High Court, 41 are in regard to cow slaughter. So, what is your take on this? Does the ambit of National Security Act extends to cover the cases of cow slaughtering?
Cow is a very sensitive topic to begin with. This is because cow is considered to be sacred among Hindus. It has reasons for that. There are mainly 3 reasons. The first one is the political reason, the second one is the economic reason, and the third one is the religious reason. The political reason is that cow is considered to be metaphor for a Hindu Rashtra and a Hindu state. And the economic reason is that cow provides us with milk and along with other draught animals, it is used for plowing the field. The third reason is the religious reason. Cow is considered to be a mother. That is why it is called as Gau Mata. Because of all these reasons, cow is considered to be sacred among Hindus. The constitutional framers were well aware of this situation. That is why they included Article 48 in the Indian Constitution. Article 48 talks about prohibition of cow slaughter and along with other draught animals. Now, as far as the cow protection laws are concerned, it is a subject matter of state list. Schedule 7, list 2nd, entry 15 to be precise, talks about the preservation, protection and improvement of stock and prevention of animal diseases. Now, if to answer your question specifically that whether the ambit of NSA covers the cases of cow slaughter, then the answer is no. This is because Uttar Pradesh has its own Uttar Pradesh Prevention of Cow Slaughter Act 1955. Section 3 of this act talks about prohibition of cow slaughter, and if the slaughtering has to take place, then the competent authority specifies the place where the butchering or the slaughtering has to be done and also specifies reasons in writing that whether the cow is above 15 years of age and also specifies whether it is permanently unfit or unserviceable. Also, with the recent June 2020 amendment, the punishment has been enhanced, which now ranges from 3 years to 10 years, also with fine which ranges from 3 lakh to 5 lakh. With these stringent laws already in place, the imposition of NSA over these cases is quite questionable. See, broadly speaking, if public order and peace and tranquility of an area is disturbed, then NSA might be invoked, and it may be in cases of cow slaughter or in other cases.
Now here is some minute data. Out of 41 cases on cow slaughter, 30 has been quashed and 10 of remaining 11 have been provided with bail. But as you mentioned in your first comment that public order is a ground and peace and tranquility too for invoking NSA. So in a society where cow is so sacred, don't you think that such a slaughter will disturb the public order?
See, in order to answer your question, one must first understand what public order is. The term public order has not been clearly interpreted yet. In general parlance, it means maintenance of an idea of a society, incorporating within it the normal social norms and the normal social behavior. There has been no conclusive and comprehensive decision of Supreme Court laying down standard as to what exactly public order means, although there has been various tests which has been derived from time to time. So whenever any act shakes the conscience of a society at large, then such act may be termed to cause public disorder. Such offences may include minor offences like publishing obscene material over the internet, as well as major offences like terrorism and rape. Mere generation of threat and insecurity in the minds of people can also be the cause of public disorder. So now it is clear that public order differs from case to case. But one thing must be kept in mind, that the act must affect the large section of people.
Now here in 7 instances, court noted that cases were of law and order and not of public order. So in normal scenario, both these terms sound synonymous. So what is exactly the legal difference?
See, every minute breach of law and order cannot be termed as a threat to public order. There is a difference between them, and this distinction is clearly brought out in the case of Ram Manohar Lohia versus State of Bihar. The court has observed something unique. Court has observed that you have to imagine 3 concentric circles. The outermost circle will represent the law and order, followed by an inner circle which represents the public order, and the smallest circle will represent the security of the state. See, it is then easy to see that an act may affect the law and order but not public order, just as an act may affect the public order but not the security of the state.
In 8 of the cases, court remarked that there was non-application of mind. So what should we understand with this non-application of mind phrase? Is it something like officials were feeling lazy to apply their mind?
Non-application of mind means not dealing with the merits of the case. It means being arbitrary. That is why the Allahabad High Court has stated instances of FIR being copied and the detainees not given proper opportunities to represent themselves and detaining solely for the purpose so that the detainees do not get bail. In order to understand what non-application of mind means, we have to refer to administrative law. See, the problem of administrative discretion is quite complex. It is true that the government cannot function without some kind of discretion being provided to them. Courts in India have developed various formulations to control the exercise of administrative discretion. These formulations can be broadly classified into 2 broad heads. First, that the authority is deemed not to have exercised its discretion at all or failure to exercise discretion. Now this is known as non-application of mind. The second is that the authority has not exercised its discretion properly or failure to exercise discretion. This is known as abuse of discretion. Now whenever authority is conferred with discretionary power, then that authority has to apply its mind and not act according to whims and fancies. So whenever an authority acts as abdication of power, that is abdications of functions, acting mechanically and not according to the law, then there is failure to exercise discretion or non-application of mind.
In 7 of the cases, the court said that the accused were not provided with fair chance to represent themselves. So here we would like to know that what is the normal procedure as per procedural law to hear an accused, and up to what extent the procedure in National Security Act varies with that.
See, when a person is normally arrested, he or she has certain basic rights. These rights include right to be informed about the grounds of the arrest and right to bail. These grounds or these procedure are laid down in Criminal Procedure Code. For example, Section 50 of CRPC provides that an arrested person has right to know about the ground of his arrest and also the right to bail. Furthermore, Section 57 and 76 of the Criminal Procedure Code enumerates that the person arrested has to be produced before magistrate within 24 hours of arrest. Section 41D of CRPC provides right to the arrested person to meet advocate of his own choice during the interrogation. Furthermore, Article 22 Clause 1 of the Constitution of India guarantees that the arrested person cannot be denied the right to consult and to be defended by the lawyer of his own choice. However, when a person is detained under the National Security Act, such basic rights are also denied. Section 8 of the National Security Act provides that an arrested person has no right to be informed about the ground of his arrest up to 5 days and in certain circumstances up to 10 days. While providing the information, the government has power to reserve information which would go against the public interest if disclosed. Further, right to seek legal aid is also denied. Section 11 Clause 4 of the National Security Act provides that a person has no right to be represented by a lawyer in matter related to proceedings of advisory board. Moreover, National Crime Record Bureau, which collect crime data, has no instances of these cases because FIR is also not registered.
As you mentioned, the normal procedure after arrest and that procedural rights are ensured by the Indian Constitution, to say Article 21 and 22. So doesn't this abnormal procedure under National Security Acts infringes the fundamental right provided by Part 3 of the Indian Constitution?
See, it is to be clearly understood that National Security Act is a special enactment which has its own procedure which is to be followed when a person is detained under it. It is also a rule of law that the special law will always prevail over the general law. Furthermore, Section 5 of the Criminal Procedure Code provides for a saving clause which says that whenever there is a special law or local law which provides for its own procedure, then that will be followed instead of CRPC. Section 9 of the Act provides that the central or the state government shall constitute one or more advisory board. Each advisory board would consist of 3 members who are or have been qualified to be judges of High Court. According to Section 10 of the Act, the person detained has to be produced before the advisory board within 3 weeks from the date of detention. The advisory board would then consider all the materials placed before it and then prepare a report, and such report will be forwarded to the central or the state government. If the advisory board considered the detention to be appropriate, then the detention would continue. But if the advisory board considers it to be unnecessary, then the appropriate government have to revoke the detention order. These provisions of National Security Act that is relating to the advisory board are in consonance with Article 22 Clause 4 of the Constitution of India, which talks about the composition of advisory board under the preventive detention laws when a person is detained for more than 3 months under it. See, the fundamental rights enshrined under Part 3 of the Constitution of India are itself not absolute and are subjected to reasonable restrictions. Further, the object of this act is not to punish but to prevent the detainee from doing something which is prejudicial to the state. The satisfaction of the concerned authority is a subjective satisfaction and depends upon grounds such as maintenance of public order, security of the state, and friendly relations with other state, and also maintenance of supplies and essential services. A person is detained without trial only on these grounds which I have discussed right now. These grounds also form the reasonable restrictions under the fundamental rights. Therefore, a detainee under the preventive detention laws has no right of personal liberty guaranteed under Article 19 and 21 of the Constitution. However, to prevent the reckless misuse of this, there have been safeguards which have been provided under the Constitution. For example, a person may be taken to preventive custody only for 3 months at once. If the period is extended beyond 3 months, then it has to be referred to the advisory board. Second, the detainee is entitled to know the grounds of his arrest, which is given under Article 22 Clause 1. And third, the detaining authorities must give the detainee earliest opportunity to represent himself.
NSA has also been used to curb CAA and NRC protest during year 2019 and 2020. And Dr. Kafil Khan, who addressed a gathering at Aligarh Muslim University in December 2019, and 2 months later, to be precise, on 29th January 2020, he was arrested under the National Security Act. So, does this preventive law can be imposed post commission of offence too?
No, it cannot be imposed after the commission of the offence. See, preventive detention means imprisonment of a person before trial on the assumption that their release would not be in the best interest of the society. There are basically two types of detention. The first one is punitive, the second one is preventive. Punitive means detention for punishment of criminal offences. This is basically after the commission of offence or when an attempt has been made towards the commission of the offence. But preventive means incarceration of person beforehand to prevent any future possibility of commission of offence. See, as far as Dr. Kafil Khan case goes, and as far as law is concerned, a person cannot be booked after 2 months under the preventive detention laws. He might be booked under any substantive law such as Indian Penal Code, but booking him under preventive law such as National Security Act is questionable.
Critics says to curb this law. So how do you take the balance between its need and restriction of its abuse in its present form?
To curb this law is not the solution. See, India is a country having multi-ethnic, multi-religious and multilingual society. Caste and communal problems are very much common in India. Apart from all this, when Indian Constitution came into force, there was a need for such legislation. I would like to quote Dr. Ambedkar in this regard. He said that in the present circumstances of the country, it may be necessary for an executive to detain a person if he is tampering either with the public order or with the defense services of the country. In such case, I don't think that the exigency of the liberty of the person detained is above the security of the state. If preventive detention laws is to remain part of Indian Constitution, then it is imperative that its use is confined to limited and specified circumstances and should include adequate safeguards so that the fundamental rights of the detainees are not infringed. There are certain safeguards or measures which can be adopted in order to improve the present situation. The first one is that the ground of maintenance of public order should be clearly defined and all situations should come under it which might attract the ground of public order to remove arbitrariness. Second, the government should bring Section 3 of 44 Amendment Act 1948 into effect, which would thereby reduce the period of detention up to 2 months. This would at least reduce the incident of torture significantly. Thirdly, the advisory board review procedure, which involves executive review of executive decision making. In such cases, the absence of judicial involvement violates the detainee's right to appear before an independent and impartial tribunal. Fourth, there must be periodic review of the detainee's case. I would like to point out a case. In the case of United States of America versus Salerno, the Supreme Court of United States of America have devised couple of safeguards to prevent the abuse of preventive laws. These includes the right to counsel as a fundamental component of the proceeding, as well as strict compliance to the speedy trial. Considering all these things, a moral assessment need to be done because at one end of the spectrum, the life and liberty of large number of people is at stake, and on the other end of the spectrum, the life and personal freedom of the person detained must be taken care of.
More than two-thirds of the cases have been quashed. Does the authority under this act or any other law are having any liability in case of power abuse? And does the victim of such abuse are liable for any kind of compensation?
See, the authorities are often saved by Section 16 of the National Security Act, which says that no suit or legal proceeding shall lie against the central or the state government for anything done in good faith or done in pursuance of the act. There have been instances where the Supreme Court has rebuked the authorities for arbitrarily invoking the National Security Act. However, no strict action has been taken against them. As far as the right to compensation is concerned, Article 9 Clause 5 of the ICCPR, which stands for International Covenant on Civil and Political Right, Article 9 Clause 5 provides for right to compensation for unlawful detention except for public emergencies. The Law Commission has observed that the recent Supreme Court orders have held that persons are entitled to effective communication, which in reality would be superseding the India's reservation on Article 9 Clause 5 of ICCPR. In this light, the Government of India should promptly withdraw its reservation on Article 9 Clause 5 of ICCPR and should provide a constitutional provision with respect to right to compensation. There have been cases where the High Court and Supreme Court have been providing compensation under Article 32 and 226 for the violation of constitutional rights.
Thank you for watching this video. If you felt it worth and if you think that we should continue it further, and if you have any topic to clutter in your mind, then kindly put it below in the comment section.